Welcome to the Maryland Injury Law Advisor video series. I'm your host, Phil Santamaria, a Maryland accident and injury lawyer. In today's video, I'm going to tell you about something that's extremely important to you, and that is how are legal fees charged in Maryland accident and injury cases. And in the course of doing so, I'm going to tell you about 4 things that are critically important for you to know when you hire a lawyer in this kind of a case. Okay, let me give you some context. Lawyers typically charge clients one of 3 ways. There is a fixed fee where you pay a certain specified amount in return for a particular service, and that usually is payable in advance. There's an hourly rate where you pay a lawyer an agreed upon amount for each hour of time the lawyer spends on your case. And normally with that sort of an arrangement, there is an advance payment requested called a retainer payment. But there's a third option, and that's the one that is traditionally proposed in accident and injury cases. And that third option is called a contingent fee, or a percentage fee. A contingent fee is contingent. It is contingent upon success. And if your case is not successful, you don't owe anything as a legal fee. If you are successful, then a percentage of the amount you recover is what you pay as a legal fee. I can think of at least 3 major advantages of a contingent fee. The first one is that if you have a good case, you can hire a lawyer even if you don't have money to put up for an advance fixed fee or an hourly rate retainer payment. All you need, as I say, is a good case. And with that, your lawyer will take your case and you won't be locked out of the system. So that literally the contingent fee is your key to the courthouse door. Second advantage is this. Lawyers can't afford to work for nothing any more than you can. So when your lawyer says to you, I'm willing to take your case on a contingent fee basis, your lawyer is saying, I have great confidence in your case. Advantage number 3 is that this arrangement incentivizes your lawyer. The larger the recovery your lawyer is able to help you get, the larger the lawyer's legal fee will be. When you hire a lawyer on a contingent fee basis in Maryland, you must have a written agreement. It's a requirement. And there are 4 things that I particularly want to point out to you to be looking for when you enter into a contract with your lawyer. The first one, of course, is the percentage. What percentage are you going to pay? Frankly, a 1/3 contingent fee is a very commonly suggested option in this kind of a case. But it's not the only one, and they do vary. Percentages do vary from law firm to law firm. Another thing to look out for is this. In some fee agreements, the contingent fee percentage is constant, doesn't change, and in other fee proposals, it does change. Under some fee proposals, the amount of percentage you will pay changes, typically increases if certain things occur, such as filing a case in court or actually going to trial, not being able to settle the case in advance and actually going to trial. I think the fairer, better system is the constant percentage fixed fee arrangement, and that's what we do in our office. No matter how long your case takes, no matter which twists and turns it takes, and what complications come into it, the percentage you pay in our office as a legal fee never changes. Detail number 2, what about the costs of your case? Don't recognize that term? Well, that's what we lawyers call the expenses of a case. These are things that have to be paid not to your lawyer, but to third persons for assisting in the case. Examples might be monies paid to your doctor, to provide copies of your medical records and bills, court filing fees, deposition costs, expert witness fees. In a normal, smallish case, terrible way to say that, I apologize for that, I hope you know what I mean. In a more routine case, these costs are a couple of $100s perhaps. But in complicated cases that actually go to trial, that involve expert witnesses, perhaps multiple expert witnesses, these costs can be tens of thousands of dollars. So 2 questions come up. Number 1, who is going to pay these costs as they are incurred? And number 2, who pays them if your case is lost? Now, some agreements, I think it may be the majority of them, but I'm not sure about this, propose that you, the client, pay the costs as they are incurred, and that you, the client, be responsible for paying those costs if your case is lost. There's an option, there's an alternative to that, and that's what we do in our office. Here's what we do. We advance every penny of your costs. If your case is unsuccessful, you do not have to pay us back. In other words, we assume the risk that your case will be lost financially. And if you, on the other hand, have a successful case, then you simply repay us the amount that we have advanced on your behalf. Next complication. What services are covered by the agreement? The contingent fee that I've been talking about is calculated based upon your recovery for your injuries. However, there are, or at least can be, other issues in your case. If it's an auto case, for example, what about damage to your property, to your vehicle? Will your lawyer assist you in getting your vehicle repaired? Will your lawyer assist you in getting a rental vehicle while that's happening? Will your lawyer assist you in making sure you get full value for your car if it's been totaled, or your other vehicle? What about the no-fault PIP claim that you have a right to file against your insurance? Will your lawyer assist you with that? In our office, we believe that all of those services are part of the package, and you don't pay anything more, no additional charge for doing any of those things for you. In fact, we look for other ways that we can add value to you and to your life and to your case. For example, if you would like, we'll be happy to review your automobile insurance policy to make sure that you have all the right coverages in all the right amounts. Fourth detail. What if your lawyer is not performing well, just isn't getting the job done, and you decide to dismiss your lawyer? Do you have any obligations to the lawyer? Frankly, there is a body of law in Maryland on this subject that, at least as I view it, is not very consumer friendly. Even though you have a contingent fee agreement and the lawyer doesn't finish the case, you may very well have an obligation, a financial obligation to that lawyer. But here's how we handle that in our office. We've never had a client dismiss us for not doing a good job, and we work really hard to make sure that never does happen. And in fact, it's our number one client service goal in every case that we have to make sure that your client experience is the best one you've ever had, or the best one you ever could have or will have. But if there's ever a time that we give you good cause to dismiss us as your lawyers, you should do so, and you certainly wouldn't owe us anything under those circumstances. Well, that's a summary of how legal fees are charged in Maryland accident and injury cases. If you have found this, if you found this information to be valuable, please give this video a thumbs up. And if you have questions or comments, put them in the comment box below. Finally, if you'd like to talk to me either about the subject of this video or about any other aspect of Maryland accident and injury law, call me anytime. Thanks for watching.